Yes, yes, Mr. Speaker, sir. I'm sorry, Mr. Speaker, sir, I didn't hear you. Yes, he's gone. He's just left. He's just left, Mr. Speaker, sir. Can I argue the other points and then I come back to it? Yes, thank you very much, Mr. Speaker, sir. So apart from relying on those two instances, the 2014 criteria by KERICHO County government, determining that 32 is the required threshold to meet 2/3 for purposes of the impeachment of the predecessor of Honorable Dr. Eric Mutai. Apart from that, and apart from the criteria also applied when the current speaker who approved of this motion also said that it was also decided that 32 MCAs required to vote in support to amount to 2/3. I wish to make reference also, Mr. Speaker, sir, to the events of the National Assembly. Mr. Speaker, sir, your colleague, the Honorable Mr. Moses Watengula, in a ruling made on 1st of October, and which I pray, Mr. Speaker, sir, you take judicial notice of, and it was in public domain, discussed the issues that had been raised by a number of MPs, being whether 2/3 is mastered by 116 MPs or 117. And the very relevant bit of that situation, Mr. Speaker, sir, and honorable senators, is that in the National Assembly, 1/3 of the total number of members of the National Assembly, being 349, came to 116.33. And so we find similarity with our case being the 0.3 in 31.3 is the same as what happened in the National Assembly being 116.3. And the speaker was very categorical saying that then the 2/3 for purposes of the 1/3 to approve the impeachment motion for the deputy president would require 117, being that you move a step further. You don't scale down to 116, you scale up to 117. And Mr. Speaker, sir, that ruling by Honorable Moses Watengula is dated 1st of October 2024, and it was in public domain. And we pray, Mr. Speaker, sir, and honorable senators, that the criteria used to elect the speaker, the criteria used to impeach Honorable Chepkoech, the criteria used to consider the impeachment of the deputy president, I know it hasn't happened, the criteria used to approve the impeachment of the deputy president at the National Assembly used one formula being that you move a step further because you cannot have a fraction of a person. That criteria should not then change in the case of Eric Mutai and be that you scale down just because it is Eric Mutai. It is our argument that that would be discriminatory. The last incident that I wish to cite is the events of Nyamira County government. In that county government, there are 34 members of county assembly. And out of the 34 members of the Nyamira County Assembly constituted of 15 nominated and 20 elected, the 1/3 was found to be 11.3. We again find the same 31.3, the 0.3 in the case of Nyamira. And in that case, the County Assembly of Nyamira adopted the approach that the 0.3 requires that you scale up to 23 people, as opposed to, sorry, 11 people, as opposed to coming back to 10 people. And for that reason, then, Mr. Speaker, sir, I insist that it would be discriminatory to deem the motion that has been brought to this assembly, to this Senate, as being competent to the extent to which it fell clearly short of 31.3. Mr. Speaker, sir, I am aware that my colleagues are restless to make the argument that this is an issue that does not quite squarely rest on your hands under the provision of section Rule 30. It is my argument, Mr. Speaker, sir, that it clearly falls within your hands, Mr. Speaker, sir. The said Rule 30 states this, Mr. Speaker, sir, where on a particular question or matter, including but not limited to the question of evidence, materiality, relevance, competency or admissibility of evidence, any question consequential or incidental thereto, where no provision has been made in the standing orders for or in these rules, the Speaker of the Senate shall rule, and your decision will be final. Mr. Speaker, sir, it is my argument that this is an issue that falls squarely in your hands. It is my argument, Mr. Speaker, sir, that when this Rule 14 and 30 was being enacted, they must have contemplated a situation like this, where you need to make a decision on a matter that, as to the competence of this impeachment motion before the senators, on this question of that is consequential as to whether we should go on or not, and all the related aspects of the competence of this impeachment motion. Mr. Speaker, sir, it is my argument that the Senate, in a certain sense, is on trial. It is on trial as to whether it will maintain the requirements of Section 33 on the at least 2/3. And the attendant aspect of the rule of law flowing from whether or not there is observance of that requirement of at least. Mr. Speaker, sir, I will request for just 7 minutes to play the video to make reference to a decision made by Justice Manani, and which is in volume 1, page 60 to page 78. And in that case, Mr. Speaker, sir, the learned judge said that where the committee requiring a certain threshold, in that case it was 1/3, where they sat over a proceeding that fell short of the 1/3, that is at paragraph 90 onwards, then page, I said it is page 60 to page 87, and in more particular, paragraph 90, which is at page 71. At page 71. Where the judge says it is perhaps also necessary to point out that Standing Order 68, subsection 8, uses mandatory term shall when directing that a DOC committee be set up and should comprise 1/3, and then goes on to say if they do not amount to 1/3, then it doesn't meet the threshold. And Mr. Speaker, sir, it is a very significant point that the learned speaker, or rather the Speaker of the County Assembly of KERICHO, used that decision, and you will find his reasoning at page 160 to 161 with reference to that case of Michael Ngaduda versus County Assembly of Tana River, and he goes on to say that you round off. And it is our argument, Mr. Speaker, sir, that when you are rounding off, you can never round off to fall below the line. You can never round off to fall to less than 1/3. And if you are to do that, then you would be acting in contravention of the law. Mr. Speaker, sir, with that said, I would pray now to play that video and request, Mr. Speaker, sir, for 5 minutes for my colleague, Mr. TENSI0N, just to finalize on that issue, on the preliminary objection. Kindly, Mr. Speaker, sir. Mr. TENSI0N, just to finalize on that issue on the preliminary.
Before we proceed to count the votes, I have a very important message to communicate. Honorable members, please note that a person shall not be elected as Speaker of the County Assembly unless supported by votes of 2/3 of all the members of the County Assembly. 2/3 for us, 47. We need to have 32 votes plus, 32 plus. Now, the candidate who in that ballot receives the highest number of votes, and the candidate who in the ballot receives the next highest, in case we don't get the 32, those are the only candidates that we shall go to round 2. Now, when we go to round 2, if they tie, we shall go to round 3. Unless that tie is broken, is when we shall declare the Speaker. Thank you. Now, I will ask The sergeant at arms, please open that thing.
I think that's okay,
Our
Mr. Speaker,
control
sir.
sheet is the number of votes first. We want to count the first 47. If they are
Mr. Speaker, sir, that shows the election of the Speaker who made the arguments that I've just referred to, in which he says, because it's at 1.3, you scale it down, you round it off to the next.
Council for Governor, we've heard the video.
Yes, thank you, Mr. Speaker, sir. Mr. Speaker, sir, then in closing, it is my submission, Mr. Speaker, sir, that there are two issues both yourself and this Honorable Senate need to address. The first issue is what is the meaning of at least in the Section 33 of County Government Act? What is the meaning? And when you apply the calculation in respect to KERICHO, does it mean 31.3 and above, or it can be scaled down to 31? So the first issue is what is the meaning of at least in Article 33 of the County Government Act, as read together with Standing Order number 74 of KERICHO County Assembly Standing Orders. Number two, the second question, Mr. Speaker, sir, is the question of how do you treat a fraction where it relates to human beings? Are you going to say because it's 0.3, you dismiss it and scale it down to 31, or even 0.3 itself represents a person? And this is very significant, Mr. Speaker, sir. When you look at the situation of these proceedings, being, Mr. Speaker, sir, that there were 47 MCAs in KERICHO. 16 said we are not attending, number one. Number two, they said we do not support the motion. The other than 31 were present and they supported the motion. Mr. Speaker, sir, following the tradition of both the Senate and the National Assembly, it is always the case that when members have not voted in favor of, it is deemed that that vote was not in favor of. And so the 16 must be treated as having opposed the motion. It cannot be given conjecture that the 0.3 could exist in the 16, Mr. Speaker, sir. It is my argument, therefore, then, Mr. Speaker, sir, that clearly it didn't meet the threshold. And, Mr. Speaker, sir, I wish to say that considering the precedent from your colleague from the National Assembly, we pray that for purposes of consistency, Mr. Speaker, sir, unless you have a very strong reason to disagree with him, you adopt the reasoning he has applied for consistency and clarity of law. And secondly, Mr. Speaker, sir, that if the criteria is used differently from Nyamira, from National Assembly, from the election of the Speaker, from the impeachment of Honorable Chepkoin, then it would amount to discrimination. Mr. Speaker, sir, I had requested for just a little latitude. I had said 5 minutes. Could you allow him just 2 minutes, Mr. Speaker, sir, kindly?
Council, your time is up. Your time is up because you kept repeating yourself. Same arguments in different form. So you may want to rest your PO there. Maybe I need to ask you.
Yes, Mr. Speaker, sir.
In response to the preliminary objection raised by, not really an objection, but a preliminary matter from the County Assembly, you have no problem the affidavit dated the 13th of October 2024 be admitted and be part of the record?
I confirm, Mr. Speaker, sir, that I have no objection, and we have discussed both of us, and subject to the Senate and you, Mr. Speaker, sir, we were agreed that they accept our replacement documents properly paginated, and we will have no objection to the.
And the application for, as far as the witness is concerned?
We strongly object, Mr. Speaker, sir. But as I said, we have this restraint of the order, and we want to be very measured not to seem to be violating the order that we already have in our favor.
Council for the County Assembly, you may now proceed to respond to the PO as raised by the Council for the Governor.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity. The two preliminary objections are opposed by the County Assembly. To that effect, Mr. Speaker, sir, we will be asking you to allow a copy of the replying affidavit to be supplied to senators, because we will be making reference to the same. It is already with the Secretariat and marked as volume 8. If that can happen, Mr. Speaker, sir, with your permission, I could proceed. The two preliminary objections.
Do you have that? Where is it contained?
It is yet to be supplied, but it is with the Secretariat pending your ruling, Mr. Speaker, sir. So we can have that done.
Which affidavit are you referring to, Council?
Volume 8 of the Governor's, of the County Assembly's documents, Volume 8.
Are you referring to the affidavit of 13th of October 2024?
Yes, indeed, Mr. Speaker, sir.
Is it contained in any of the volumes, or it's a standalone?
It's a standalone volume titled Volume
So
8.
can the volume 8 be made
Volume
available
8.
to honorable senators?
Yes.
It's a standalone volume, volume 8.
I can confirm it is with the Secretariat,
Very
Mr.
well.
Speaker, sir.
Just
But I could proceed because I will not be
you
making
may proceed,
reference.
you may proceed.
Thank you. Mr.
proceed, Council.
We object to the two POs on the ground that the very nature of a PO, Mr. Speaker, sir, and honorable senators, is that it has to be on a pure question of law. What Council for the Governor is inviting you to do at this juncture is to consider matters that are disputed, matters of fact. It is settled law that if an issue is contested, if an issue is in dispute, that can only be determined by way of evidence. When you look at the issue of existence or non-existence of the court orders, the County Assembly has strongly opposed that line of argument and has brought evidence to show that there were not court orders. In fact, the County Assembly is arguing that those court orders are either forged or a manipulation of the judiciary system. That evidence can only be tested if we bring a witness before you to be able to clarify on that issue. That cannot be done by just submissions from the bar. On the issue of whether the motion met the threshold, the 2/3 rule, again, Mr. Speaker, sir, you will note that this is an issue that has been contested. We will be producing evidence before you to indicate indeed that that threshold was met. How then, honorable senators, are you able to make a determination without listening to the evidence, without looking at the materials that both parties are relying on? We submit that the only way to do that is to allow this matter to proceed on merit. Then you can question the validity of a certain fact by cross-examination, by examination in chief, and by questioning the witnesses that will be relying, or rather seeking to produce those particular evidences. I note that Council has sought to rely on Rule 14 and 30 of your rules here to make an assertion that the decision on the two POs lies with the Speaker. We beg to differ, Mr. Speaker, sir, on the following reasons. One is that today the Senate sits not as a legislative house, but a quasi-judicial body. So any decision to be made must be made in your capacity as a quasi-judicial body. So the question then is, who is sitting to hear the matter of impeachment of the governor? Is it the Speaker or is it an individual senator? My submission is that it is the House that is seeking to listen and give a determination on the question of the impeachment of a governor. And judicial authority is usually aimed at settling a dispute between two parties. There are two ways of making that determination. One is on a technicality or on a preliminary basis. Two is through hearing on the merits of the case and making a determination. Either way, that decision can only come from the fact finder, from the judge, from the jury. So the invitation that the Speaker sitting in his capacity as a speaker can make this determination means that the decision of impeaching the governor or not impeaching a governor shall have been made by the speaker alone, who does not have the legal mandate to listen individually to an issue pertaining impeachment of a governor. On that basis, then, I invite my learned friend, Mr. Njenga, to take you through the merits of the two objections. Thank you, Mr. Speaker, sir.
Mr. Speaker, honorable members, I'll go straight to the objections because of time. In addition to the argument made by my learned friend, I invite the Honorable House, August House, to consider the import and purport of Rule 2 of the third schedule of the standing orders, which grants express jurisdiction to the Senate on two things: A, to investigate the matter, and two, to make determination on the particulars of the allegations. It is our submission that the power to make the determination, even on issues of law, remains always with the Senate, and it cannot be derogated by the application or by the interpretation of Rule 30. Rule 30 is clear. It's only on admission, competence, and any other issue regarding evidence, but not the competence of the entire motion. I proceed to respond on the question of the court orders that have been referred to by counsel. In making this response, I refer entirely to volume 8, that is the reply in affidavit of the County Assembly. I'll urge 3 quick points on that because of time, so that I can allow my colleague to refer to the last limb of the PO. First, we refer you to paragraph 8 to 13 of that reply in affidavit that speaks to the validity of the orders. The County Assembly position is that those orders are invalid. Those orders cannot be validated in the manner that is provided for by the judiciary. They cannot be validated from the judiciary CTS portal. Once you interrogate them against the practice directions of the High Court and all courts that we have already supplied a copy of, then you'll find that there is no means to verify as a house whether those orders indeed issued from the court. And that you'll find the particulars at paragraph 13. Interestingly, and we have a copy of the said orders, you will see as annexed in our affidavit, you'll see, for example, the first order that purportedly issued on the 2nd of October when the motion was being debated before the House. The parties to that order were the County Assembly and the Speaker of the County Assembly. But it appears that the orders mutated a day after without any reference to the procedure allowed and known to all of us as provided for under Rule 18 of the Mutunga Rules as to how you can amend a petition and amend a motion before the House. So they mutated on the 3rd of October to thereafter bring the Senate and the Speaker of the Senate as parties to the order. How did they mutate? How was Senate and the Speaker brought to the same matter within a day without its participation? You will see that we have referred to the screenshots that made the County Assembly aware of these orders. These orders, the County Assembly has taken the position that it was not served with those orders, and that is paragraph 9 of the reply in affidavit. That's an issue of fact that shall require strict proof. We have not been led to any affidavit of service by counsel as to indicate whether those orders were served. It is straight law that an order that has not been served is inoperative for all intents and purposes, including these proceedings. the orders appear to have been, and I'm referring to page 8 of this volume. If you look at the timestamp on top, they appear to have been circulated as early as 11:50 a.m. But when you go to the CTS portal of the judiciary, the application that yielded these orders was filed at 12:10. So we have a situation, honorable members, where an order issued before even the application was filed. That is for the Senate to consider, and we have escalated that matter as an issue of investigation before the JSC, Judicial Service Commission. We have annexed a letter, a very comprehensive letter, that I do not wish to reiterate its contents on before this House. Secondly, as I finish, without prejudice to those arguments, we have argued, and I want to make reference to paragraph 19 of the reply in affidavit. We have argued on the import of these orders. Are they applicable to the Senate, to the intent of stopping the Senate from hearing these particular impeachment proceedings? We have referred to the decision by the Supreme Court in the Justice Kariuki Mate matter. This decision is annexed for the benefit of Senate. It's a decision that I had the pleasure of arguing in the Supreme Court together with Senator Professor Ojenda, who is seated here, where the Supreme Court was quite explicit that a court cannot restrain a constitutional organ that is operating within its time-bound constitutional limits. And that I refer to the holding of the Supreme Court at paragraph 11, which you'll find at page 20 of the volume. The import of that holding to this House is that the two orders referred to by counsel for the county governor cannot serve or cannot have the effect of stopping the proceedings before this House. And finally, as I sit down, this Senate has already taken a position in that matter. I will do nothing more than refer the Senate to page 59. Page 59, this will be the last document I refer to because of time. Yes, I'm actually yielding the floor to my colleague. Page 59 is a position taken by the Senate in these proceedings, in this matter. And the Senate has said, by way of a preliminary objection, that we are not bound by that order. It has told the High Court in no uncertain terms that we are not bound by that order to the extent that it does not comply with the settled jurisprudence by the Supreme Court, which has been followed with approval by the Court of Appeal in the Mwangaza case and in many other cases, including decisions of the Senate, specifically in the Sonko matter and also in the Wambora 2 matter, which decisions are within the House. I yield the floor to my colleague to urge the issue of the threshold, the number threshold. Thank you.
Mr. Speaker, sir, honorable members, for the record, my name is Hilary Kiplangat. I will address the third preliminary objection, which is the question of whether the threshold of 2/3 required by Section 33 of the County Governments Act was met in the impeachment of Governor Honorable Eric Mutai. Mr. Speaker, sir, honorable members, Section 33 of the County Governments Act indeed requires the County Assembly to satisfy a threshold of 2/3 of its members to pass a motion for the impeachment of the governor. The controversy in this case, Honorable Speaker, is that 31 members voted in support of the motion, and in the humble submissions of the Speaker as per the Hansard of that day, that constituted 2/3 of the members of the County Assembly. Mr. Speaker, sir, in his ruling, the Speaker of the County Assembly, in page 131 of volume 1 of our documents, allowed himself to be guided by a decision of the High Court, and that is the case of Michael Justin Ngaduda versus the County Assembly of Tana River and 4 others. KELRC 1605, in which a judge of the High Court by the name Justice Manani had held that when it comes to matters rounding off, one rounds off to the nearest whole number. So, Mr. Speaker, sir, when it came to that determination, the Speaker of the County Assembly was guided by a constitutional position which had been determined by the High Court in that particular case which I have cited. Mr. Speaker, sir, that position that is volume 1 of our documents, page 131, you will find the ruling of the Speaker in which he cited the case of Justin Ngaduda versus the County Assembly of Tana River. Mr. Speaker, sir, the decision of Justice Manani is an application of elementary mathematical rule of rounding off, in which numbers are ordinarily rounded off to the nearest whole number. The same formula, Mr. Speaker, sir, has been applied in various other decisions of courts, and a case in point is the case of Adrian Kamodho Njenga versus Judicial Service Commission, which interrogated the composition of the Supreme Court in compliance with the requirements that no more than 2/3 of the same gender shall be in that appointive position. And in that case, Honorable Speaker, the High Court and the Court of Appeal were very clear that when it comes to rounding off, you round off to the nearest whole number. So the reigning jurisprudence which has been handed down by our courts is that one rounds off to the nearest whole number. In this particular case, honorable members, and Mr. Speaker, sir, there are 47 members of the County Assembly of KERICHO. To achieve 2/3 of 47, it will give you a number of 31.33. The nearest whole number to 31.33 is 31, not 32. That is in keeping with the jurisprudence which has been settled by our courts. Suffice to note, honorable members and Mr. Speaker, sir, in County Assembly of KERICHO, there are 30 electoral wards. Out of the 30 electoral wards, 29 men were elected as MCAs, and 1 woman was elected as a member of the County Assembly. IEBC, in constituting the gender quotas for purposes of nominations, nominated an additional 2 men, making the number to be 31 men against 15 nominated women. Thus, the number of nominated women in the County Assembly is 16. So, 31 men in the wisdom of IEBC, and it is important to note that IEBC is a constitutionally mandated body that can ascertain gender quotas as per the law, and in their wisdom, 2/3 is 31. And that is why at the County Assembly of KERICHO today, we have 31 men and 16 women MCAs. even if we were to convert these figures, Honorable Speaker, to percentages, you will realize that if we were to argue that 32 was 2/3, it would yield a percentage of 68.05%. And in actual sense, 2/3 would be a percentage of 66.67. So you will see that variance even if you convert those figures into percentages. And in any event, honorable members, Mr. Speaker, sir, if one was to argue logically that 2/3 is 32 and a third is 16, we would be having a figure of 48 MCAs in the County Assembly of KERICHO, which is not in actual sense the position, because we have 47 members of the County Assembly. So, honorable members, this is a constitutional question which has been settled by the courts in Kenya, and keeping with the doctrine of stare decisis, which provides that bodies adjudicating on disputes which touches on the constitution or the law are bound by the decision of the High Court or Superior Court. The decision in the case of Ngaduda versus the County Assembly of Tana River, as well as Adrian Jenga Kamodo versus Judicial Service Commission, is binding in this House. It doesn't matter how many times the county assemblies or parliament has applied a different formula. The only time when this matter has come up for determination is before the High Court, and the High Court has given a finding that you round off to the nearest whole number when you are confronted with an issue which requires numbers to be rounded off. Mr. Speaker, sir, those are our submissions in respect of the third preliminary objection, unless my learned senior, Mr. Bosek, has to add, which you can give him a minute or so.
Clerk, how much time is still available to the County Assembly?
Yes, just to add a few more points, Mr. Speaker, sir. The answer that we've been supplied by learned friend Katwa Kigen have not been certified and also are not complete. I wish to also point out that when you look at what is purported to be the answered, there is a disclaimer that this electronic version of the official answered report is for information purposes only. A certified version of the report can be obtained from the answered editor. Mr. Speaker, sir, honorable senators, we have not been furnished with any document that shows that the same had been certified by the answered senator. In fact, we are not seeing any input from the answered senator. Having said that, we therefore stand to say that whatever that has been produced purported to be from the KERICHO County Assembly, just like the documents which were purported to have been produced from the High Court in form of orders, did not go through the process of certification, and therefore they are of no probative value. And on that basis, we urge the honorable senators to look at them and to also question why council will produce documents which are in themselves self-defeating. I say no more. Thank you, Mr. Speaker, sir, honorable senators.
Thank you. Before I allow senators to make the intervention, Counsel for Governor, you may make your rejoinder.
Thank you very much, Mr. Speaker, sir. The first and the point I really just want to emphasize that for the honorable governor, we place a lot of premium on the contention that the 2/3 was not met. And as a starting point in response to what my colleagues have said, Mr. Speaker, sir, it can be taken as an absolute fact that it was actually 31 people who voted, and that that what was required was 31.3. So that it then leaves the question, as we already posed, as to whether when you scale down to 31, and as my learned friend Mr. Hillary has said, you round off to the nearest number, whether you would still be meeting the requirements of Section 33, being at least to that. The second argument I wish to make in response to the arguments is the question of whether this is a question of fact. Mr. Speaker, sir, and honorable senators, they said it is a question of fact. They will call a witness to say this and this, but we are all in agreement on what the bottom lines are. It is governed by Section 33 of County Governments Act. It's governed by Section 74 of KERICHO County Government Standing Orders. The county assembly members is 47. Those who voted at 31, the requirements is 31.3. Those are absolute facts which are not in contention, and no witness can change them one way or the other. So then, Mr. Speaker, sir, and honorable senators, the issue is ripe for your determination. It is ripe for your determination as to whether you can scale down 31.3 to 31. My colleague has also said that Mr. Boseka said that the handsets we have relied on have not been certified. We wish to point out, Mr. Speaker, sir, that the handsets on their face say the handsets are for information purposes. And Mr. Speaker, sir, we are happy enough to rely on them to the extent to which they represent information, Mr. Speaker, sir. It is of significance also that they do not deny that those are accurate representation of what happened in the County Assembly during the impeachment of the predecessor of Eric, that is Honorable Chepcoin, and they do not contest that that was the criteria used to elect the Speaker. Mr. Speaker, sir, then there is the contest about the question of the orders. Mr. Speaker, sir, we take this Senate very seriously, and we cannot possibly have come with forged orders. And we are really, really astounded that advocates of the magnitude and the standing of the County Assembly could possibly say that the orders are a forgery. Now, the specific allegation that the orders were not served, Mr. Speaker, sir, volume 2 at page 487 shows that the orders were indeed served, and there's an affidavit of service. You will also see from the Hansard brought by the County Assembly that, first of all, the affidavit of service shows the service was effected between 9:10 and 10 o'clock. The voting for purposes of the impeachment was done at 2, as can be seen in the answer that was produced by the County Assembly at page 58. If you go at page 160, at page 161, it shows that they completed their process of impeachment at 2:18. So clearly, service was effected long before they did the voting. Mr. Speaker, sir, we stand with the orders. It is also significant that they say there was a forgery, but my very good friend, Mr. Hillary, filed a notice of appointment to come into that case the day after, on the 3rd of October. If they are saying there were no orders, what were they doing getting into that case and participating in that case saying we want to represent the County Assembly and challenge the orders obtained? And Mr. Speaker, sir, we take exception at the allegations made about the orders not being proper. Mr. Speaker, sir, with that, I would like to rest my response and request for your indulgence for just 1 minute for my learned friend, Mr. TENSI0N, to just say one thing, and we rest our case. Kindly, Mr. Speaker, sir.
Honorable Speaker, members of the House, for the record purposes, my name is TENSI0N Manasseh, and I rise only to respond to one issue, Mr. Speaker, and that is the and that is the issue of 2/3. as indicated by my learned colleague, Mr. Hillary. Honorable Speaker, the issue of 2/3 is not a mathematical question in this instance. It is indeed a legal question. And if you take, for instance, Mr. Speaker, that at 31.3, a line of a threshold has been drawn. And the law states, and in mandatory terms, that it should be at least 31.3. That means that you have to scale up the numbers to meet that threshold. Because if you reduce the numbers to 31.1 or 31, that means that you've fallen below the threshold that is provided by law. Mr. Speaker, as you are aware, even in the standing orders of this House, standing order 7 in the election of the Speaker, Mr. Speaker, the House is composed of 67 senators, and 2/3 of that is a decimal point. Mr. Speaker, and as you can recall, on your election, the numbers were scaled up and not scaled down. This means that you do not reduce the number below what the law provides. So, Mr. Speaker, as you rule or as the House debates on that, consider that a 0.3 of a person needs to be completed. You do not negate or remove that particular person. So in our submission, we hold the position that the threshold was not met. Mr. Speaker, and also one issue that Hillary raised, and it was containing the issue of the gender in the County Assembly of Kericho. Honorable Speaker, the issue of gender in the County of Kericho is not the same and is not captured under Section 33 of the County Governments Act. Mr. Speaker, we urge the House to look at what the law provides and if we can scale down to that. And this House, Mr. Speaker, let it not be the House that sets the record or give precedence that you can play with numbers. Let the House be very firm in its decision and uphold the rule of law. That will be all, Honorable Speaker.
Thank you, Council for the County Assembly and Council for the Governor. Now, I will allow honorable senators to make intervention in this regard. Now, honorable senators, you will notice that this is not the ordinary preliminary objection that we've been dealt with before. It's a preliminary objection that is of a fundamental nature. It may or may not terminate these proceedings. And therefore, as you make your intervention, have that in mind. I will start